So, ladies and gentlemen, we have a very distinguished panel of speakers here for you today. Are there any questions from the floor? Everybody's afraid of our panel of speakers. Perhaps I could kick off the session maybe by asking Mr. Olbourne, if I could, on the case study which you have just presented. And maybe any of the speakers, if you have an opinion or a view, maybe you could just jump in. From the fallout of the case of the Pincher case, which we have discussed today, how do you see the effect of such a case on the relevance which CAS may have in the future in resolving sports disputes?
There are others on the couch here who may be able to speak more or speak better to that question. It seems to me that it's going to have no effect at all. What it will do, it may be a positive effect in that it brings CAS more to the attention of a wider public, particularly in the international arbitration sphere. In my view, what it will do is it may give rise to more challenges in domestic courts based on the clever lawyer-type arguments that were raised in that case and in one or two others. But fundamentally, I don't think it's going to change the process too much at all.
This is yes, I mean,
Could I just add to that, my Peter? I doubt very much whether that decision is going to be upheld on appeal of the civil decision. But I think there will be more interest is the decision of the European Court of Justice, because competition law and European law with the European Supreme Court having a final say sometimes become up with decisions which are not generally acceptable because they're driven by human rights considerations rather than commercial considerations. That's one issue. Well, I don't see how, if you make a decision like that, for instance, the High Court, it's as good as saying you can't sue the German government in a German court because German judges are appointed by the German government. That's right. And the system fails. It's very hard to think of how any decision is going to do away with CAS.
Could I ask a question? To Guru Tansri Imran, the proposed arbitration panel between the OCM and the place in which we're sitting today, does that come under the proposed amendment to the Sports Act? The reason for the question being that it's obviously a hugely important step in the development of our arbitration system. The Sports Act was formed in 1997 when the present Prime Minister, I think, was Minister of Youth and Sport himself. It's taking a very long time to amend. Much longer do you think it will take to have the amendments done? And could it be done in stages? The Minister himself this morning said maybe next year is too early. It concerns me that the momentum that has been started is being affected if we can't be implemented.
There's already a draft which the panel, that they have under the Sports Commissioners and under the Act is actually looking at it as he said, and I believe it's going to be sometime next year. Quite honestly, I think he's very keen that this is one of his legacies. And as you know, sports ministers only last for one term because then they get promoted to higher ministries. So I think this is one of the legacies that he wants to leave behind before he leaves. So I think it'll happen, Chris. It will be part of the SDA, and we want it to be part of the SDA because one needs to be, we have the force of the law, so that then all the athletes, clubs, associations will heed it. And as I said earlier, we had an ADR process in the Olympic Council of Malaysia, which never no one ever used. So I think that the fact that one it will be seen as independently run, independent of government, and independent of any of the sporting bodies, because it's going to be run by KLRCA. I think that's another positive point, I think, for this sports tribunal. You know, independence, I think, is and perceived independence is important. Just a comment on ICAS. I sat on ICAS for 10 years. You know, quite honestly, I think that you know, there's, you know, all that ICAS does in terms of appointment of the arbitrators is the first appointment. After that, it's really the administration that then, you know, appoints the ones for the judges for the cases. So, you know, the ICAS is very much a policy-making body. They're not making decisions as to whom really gets appointed, you know, for which case.
Could I ask Ben, you did suggest that the danger of sort of repetition of that case could be reduced by some relatively simple amendments. For example, when a judge is appointed, does he have to sign some kind of declaration that he has no involvement with that particular sport?
Yeah, yes, that is there now. There are a number of possible changes that could be made. One simple one, and I take on board the comments about ICAS's quite limited role, but one simple one could be to change the way that the arbitrators are nominated to the CAS panel by having a system where there is equal representation between bodies representing athletes and bodies representing associations. At the moment, there is a heavy weighting in favour of associations, and that could be made more even. There are other fairly easy measures that could be put in place. One concern has been that a number of the arbitrators on the CAS panel are routinely appointed by the same governments or what other bodies, and a little bit of bias or appearance of bias can develop because the arbitrators are seeking to continue to get repeat appointments. That can be avoided by having more transparency as the number of times any particular arbitrator is appointed by any particular sort of party. So that sort of measure, which is very common in most other international arbitral institutions, I think could be easily applied to CAS with very little objection from stakeholders.
I'd just like to return to the observation or to the point made about the National Sporting Tribunal that Malaysia is seeking to set up soon. What should have also been included in the slides for THAC is that Thailand is also in need of such a national mechanism. We don't have one yet, but with the proliferation of sporting disputes and the increased commercialization of sporting disputes, I think it's unavoidable that we would have one down the road. So we're eagerly anticipating what our friends here at KLRCA and in Malaysia are going to do.
This is a template for the Thailand.
Yes, thank you.
I believe there's a question from the floor at the back. Yes. Yeah. We'll take this question and then we'll move on to the next session.
Just on the aspect of training and accreditation, what are the challenges you see in terms of ensuring this region receives a CAS approved arbitrator or so that can fairly hear or does have the expertise to hear disputes between athletes or stakeholders in general? What are the challenges you see in training and accreditation in that sense? Yeah.
Is there anyone you are directing a question?
Just a general question to this panel.
Well, unfortunately, there's no one sitting up here from the KLRCA, but certainly we're looking at in Malaysia. You know, the panel. We're looking for people. Maybe many of you in this room would like to, as Dato Bill mentioned earlier. You know, we're looking at not semi-pro bono, almost pro bono in order to be able to be, dispense justice inexpensively. And so, there's the KLRCA will be, have agreed to run the courses, do the training, assess the panelists, and hopefully before we commence, there will be a number of panelists, a panel of arbitrators from all different areas, not necessarily sports people, there can be engineers, lawyers, etc., but maybe with some sort of knowledge of sport without, again, not being any part of any sporting body. That's what we're trying to achieve, is the independence, fairness, transparency. And I'm sure that the KLRCA will do a great job in the training.
And the willingness to work pro bono, of course. Ladies and gentlemen, due to constraint of time, we'll be ending our question and answer session here. I do, if I may ask the speakers to just remain on stage for a short while. We have a few tokens of appreciations to present to all our speakers today. Ladies and gentlemen, could I get a big round of applause for all our speakers?
Well, sports arbitration is certainly evolving across the globe, and it will be interesting to see how things develop here in this region over the next few years. Ladies and gentlemen, I know that based on of your name tags as well, we are actually scheduled to go for lunch. Unfortunately, we have to delay that slightly, and we hope that we fed you enough over the 2 rounds of breakfast just to hold you up for another hour. We'll jump straight into the second session of the day. But just one short announcement in that we are merging session 4 and session 5, and so there will be 3 speakers in session 4 who will be speaking about integrity of sports.